Okay, we're on the air. Good evening. Welcome to the July 24th, 2017 P&Z Commission, aka Land Planning Agency. And I'd like to, excuse me, July 11th, isn't it?
Thank you. I misheard that.
I might have.
I think it said 16th, yeah.
11th. Oh, I was thinking 17. Okay, excuse me. If I could have your attention, please, let's call this meeting to order at this time and stand for the Pledge of Allegiance and a moment of silence for all the men and women in uniform, our men and women in uniform around the world. Pledge, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I thank you. Now a moment of silence, please. Amen. Thank you.
I'd like to point out, Mr. Chairman, that we lost 16 Marines yesterday in an airplane crash in
Yes, I heard
Mississippi.
that. I still don't know what the details are, but it's unfortunate at any rate. All those people are doing us service and are at risk
Every day.
all the time,
Every
24/7.
day.
And we'll be forever in gratitude to them. Hope you all had a great 4th of July and understood what the birthday of our country is all about. If you can do the roll call, Kathy?
Yes.
Appreciate it.
Chairman McKee,
Here.
Vice Chairman Keithler,
Here.
Member West is absent excused. Member Sills.
Here.
Member Evans.
Here.
Member Richmond.
Here.
Member Wunderlich.
Here.
Member Henderson is absent excused. Member Fromer.
Here.
We have a quorum.
And we have 5 members of the quorum. Thank you. All right, we're going to bring out the consent agenda, which is the minutes of the Planning and Zoning meeting of June 13th, 2017. And the second one is Sunbelt Final Site Plan. If there's no questions concerned about those items, we'll just ask for a motion to approve the consent agenda.
I have some questions on the final site plan.
All right, we will extract that from the consent agenda, which leaves us with the minutes of the Planning and Zoning Commission meeting for June 13th. So we'll pull those out. Any questions on that meeting minutes? Hearing none, I'll ask for a motion to accept those.
I'll make a motion to approve the minutes.
Thank you, Jim. I need a second.
Second.
We have a couple seconds over here. Mr. Richmond and Ms. Evans. All right, any other further discussion? Hearing none, we'll call for the question. All those in favor of the minutes of the Planning and Zoning Commission, please say aye.
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 Anyone opposed? Hearing none?
I'm going to abstain since I was not there at the meeting.
Oh, and we have
Okay.
one abstention. So it's not unanimous. All right, I guess we got to pull out the Sunbelt Rental Final Site Plan. And I guess you'd probably pose your question to
Yeah, I just posted
Planner
Mike.
Michael Roomer. Are you available for comment, sir? Thank you.
And this may just be a memory flaw on my part, Mike, but I seem to remember we were going to get 10 feet to make the right-of-way 100 feet across, not 5 feet.
5 feet from each side of the road, so as the next guy comes in across the road, he gets 5 feet.
But there was always 5 feet that these guys were
Yes.
giving us?
Yes.
And am I mistaken? It looks like on this that it's the sidewalk. Is that
No.
the case?
The sidewalk will not be, the sidewalk will be outside the right of way. The dedication's gonna happen with a plat, so the property will be transferred over to the city, and the sidewalk will be on the edge of the right of way.
Okay. And so what's changed with this since what we looked at last time?
This is just the, no changes. There's a change on a size of a water pipe based off a comment from FDEP from yeah, so there's just a detail change in there.
It seems like we have more detail on the
Yes.
drawings and the buildings and things like that
Yes,
as well. Yeah.
so that's what we require at final. That's where the proof is
Okay.
in the pudding. You'll see with regards to the landscape plan, on the southern edge of the property. It's adjacent to our Public Works facility.
Right.
And they have, as part of our building of the Lake Shore Center, which we tore down and built on top of the old one, but we had to build, St. John's made us build a pond somewhere for the impervious. So we built a stormwater pond on our Public Works site. It's walled, it's retaining walled, and it's very important. So because of maintenance of that pond and its function, Public Works asked that there weren't large trees adjacent to that were gonna drop
Shed
trees
leaves
in there
and
and mess
stuff,
up.
yeah.
So we've adjusted some of the landscaping on the Public Works side, put those on the west side for the 429. So that would be something I want to point out.
We've got some Muscovy ducks that have moved into our neighborhood. We'd be happy to put over there on that pond.
Russian spies.
Yeah. So, nothing really other than just detailing the buildings and
Well,
elevations
this-
and stuff.
From the preliminary, you just had a few pages. This is
Right.
making the stormwater retention work. This is making all of the utility connections, the fire hydrants. It's in the details for the construction crew that's out there.
Is there any change to the margin on the leasable parcel that was next to the property? We had the gentleman here last time that was concerned about the ditch
Right.
that's there. Is there any change to what's
No,
going on
that
with that?
parcel is the same size. The buildings shown on the first phase
Yeah.
are the exact same size as they were in the
Okay.
preliminary plan you saw.
There's no change in that? Okay.
The only change, and it was made before, you may have seen under preliminary, a preliminary subdivision plan. And it changed, they're not going to subdivide, it's all gonna be owned by Sunbelt Rental, so there was the option of making 3 lots.
Yeah, that's
And
what
that
the
back
option
one
is,
could have
right.
Yeah.
been.
Yeah,
Could have been sold, yeah.
Could have been sold, that's gone away.
So
There's
it's
no
always going to be
subdivision. Right.
Sunbelt
It's
property?
always, yes, and they're going to
One
just
parcel.
do most likely a 1-lot plat, just for all the dedications and all the easements and all that. So you'll hear about a Sunbelt plat, but it's only for 1 lot.
okay.
It's-
So the
'cause
whole
this is
thing's one lot?
A whole, yes, in a stormwater tract, and it makes it cleaner.
Okay,
I have no other questions, Mr. Chairman.
thank you. Mike, I presume since this was on the consent agenda, that all the outstanding issues with the staff and the owner were resolved?
Yes, just 2 pages will be changed on this plan that goes to City Commission on that force main detail going to the different size pipe, and that affects 2 pages.
Okay. All right. Hearing that, I will bring it before the commission to make a motion to accept that final site plan.
So moved. Do we need to say all the words
I'm looking for the numbers.
about
here.
the local planning agency and all that stuff?
Yeah, you can just do motion, this is on consent, yep, that's sufficient.
Pardon me?
Just motion to approve.
Oh,
this.
okay.
A motion to
All right.
approve, okay.
So we have a motion to approve the final site plan for the Sunbelt rental. Do I hear a second?
I'll second that.
Okay. Mr. Wonderlich seconded that. Any other discussion of that item? Hearing none, I'll call for a motion or a vote. All those in favor say aye.
Aye.
Aye. Anyone opposed? Hearing none, accepted unanimously. Thank you. And we're on to the next issue. We have no old business, so we're on to the new business, which is a sunshine law update presented by City Attorney Dana Crosby Collier.
Thank you.
Welcome.
And I'm very glad to be here to discuss these items with you all. We have so many new members that we thought that this would be a good time to come to y'all and discuss sunshine law, public records law, and ethics law, and I'm so glad that almost everyone is here tonight. So we're going to start out with Florida's sunshine law, which, as I mentioned, consists of 2 parts. The public meetings law, which is what we do once a month on a second Tuesday, and the second part of it is the public records law, which has to do with records and documents that are generated in the course of your board service. So starting with the one we always think of as the sunshine law, which is the public meetings law. It actually is required that all meetings be open to the public in the state's constitution. So the legislature did some rules and put some language in the law at section 286.011. and I'll talk about those in a moment. A few years ago, in 2013, they amended the law a little bit to require that the boards hear from the public before you take final action. And we also have a resource, and I'll give you the website at the end, through the Attorney General's office, called the Florida Government in the Sunshine Manual. It's an excellent resource for anything relating to these public meetings laws or the public records law. So regarding public meetings law, all meetings in which official acts are taken or public business is transmitted are public meetings, and they must be open to the public at all times. So the question frequently comes up, well, who is this group to which this applies? And it applies to a local government board like you all, or an appointed board, or it applies to our city commission, an elected board. Sometimes it applies to private companies when they do business on behalf of government. It could apply in a situation where one person is acting on behalf of a board or commission, is dispatched to go do things for the benefit of the government. It applies, though, in all cases to meetings of 2 or more members of a board when they are discussing matters that foreseeably may come before the board. So what that means is anytime you all are talking about something that may come before the P&Z, you want to make sure you're doing it in the sunshine, on the dais, with the doors open, the clerk taking minutes, and everyone here. You know, if you happen to encounter one another at the Publix or whatever, you know, of course you meet, you greet, you speak, you know, and social, but don't discuss anything that may come before this board in that context. All those discussions need to happen here. Another thing that sometimes people don't really think about is we dispatch emails to everyone. You know, we're having a meeting on Tuesday night. Please let the clerk know you're going to be here. And it happens sometimes, and it's inadvertent, that someone hits reply to all, and they start this discussion via email with other board members, which we're not supposed to do, because it's, you know, we're supposed to always have our discussions in the sunshine and on the dais and before the clerk, and with regard to the open door policy. So the rules are pretty simple. There must be reasonable notice given of all meetings. So when we call a meeting, we notice it usually a couple of days, several days in advance. In our case with P&Z, we notice it. It's on the calendar. It's a given. The second Tuesday of every month we're going to meet unless it's canceled. The clerk must take the meeting minutes. Those meeting minutes are open for public inspection, which means at any time someone can come in and see the minutes and review them or copy them. And as I mentioned, since 2013, the public must be given a reasonable opportunity to be heard on any proposition before a board or commission takes its final action. So there had been some case law. Some people showed up at this contentious water management district meeting, and they wanted to be heard. You know, they were flooding out into the lobby, and the board said, no, you know, we don't. Sunshine doesn't mean we have to hear from you. You could be here, you can look at our minutes, the clerk sees she's taken them, but we don't need to hear, you know, from you. And so the legislature said, you know, there's just they're right, but there's something wrong about that. So in 2013, they changed the law so that people must be heard. And as you know, with this particular board, just about everything we do is a public hearing, so that's a given. On some of our other board agendas, we add a public comment period at the beginning or the end, so people can be heard before action is taken. What does sunshine mean? It means that, I think we've probably pretty much gone through this, it means that whatever we do must be done in the sunshine. It must be done on the dais. If you have a telephone conversation with one another, don't talk about board business that may foreseeably come before the board. You can't use computers to conduct private discussions like I mentioned with the email. Anything that we talk about with regard to this board, we talk about in the sunshine. And I just want to mention, because it comes up, we've had cases in Florida where people were married, they're on the board and they're married, or people socialize socially and they're at Christmas parties and whatnot, and that's fine. I mean, of course you socialize and carry on with one another as normal. You just don't discuss board business, and that's just the rule of thumb. It's a serious penalty if there's a violation. It can be a second-degree misdemeanor if it's a knowing violation, meaning that you knew I think W.D. Childers in North Florida is probably the textbook example of what not to do. He would go in the back room and talk about business, and he ended up going to jail. In the Senate, it was okay. In the county commission, it wasn't. You can be fined up to $500 for a violation. So we do take it seriously, and if ever there's any questions, you would want to contact me or the city attorney to discuss those questions.
They'll just take that out of our pay, right, that $500?
Yeah. I know you're so well compensated on this board. But the second part of it is the public records law, and this is another thing that we get from our Florida Constitution. The law says, the Constitution says that all records created by a public entity are public records, unless they're exempt. So there's a chapter in Florida law, 119 Florida statutes, that talks a lot about what is a public record, and it has a few exemptions. But you know, the Florida statutes are this wide now, and they are littered through A to Z, 1 to 1,000, with exemptions. Because the legislature will enact some kind of a law, and they'll realize that there needs to be an exemption. For example, they just did a rewrite of the medical marijuana law in Florida in their special session, and they passed a bill, and the companion bill was a public records exemption for some of that information. I haven't read the bill, the public records bill, but it was one that I glanced at when I was looking at the main bill. So it's very, very common that you'll see exemptions come along with bills that are, confidential, talk about confidential information, the addresses of people who are police officers and things of that nature, that's just not to be released to the public. But we also go to the Government in the Sunshine Manual a lot for questions regarding public records law, because there's just all kinds of little nuances when there's a question, and the clerk can attest to this. We can spend a while looking at the question and the case law and the opinions and whatnot. But the general rule is that every person has the right to inspect or copy any public record made or received in connection with the, and this is the important part, transaction of official business by a public body. So if you were to email one another and confirm lunch on Friday, that's not a public record, that's purely personal correspondence. As soon as you insert into that email information, I'll see you at lunch on Friday, and I'll bring that draft copy of the medical marijuana ordinance. Now we have a public record because we're using that email to transact official business, to communicate official business. So purely personal correspondence is not a public record, but anytime you get into official business, anytime you're creating something that's going to perpetuate or communicate or formalize the knowledge that relates to the official agency business, then you have created a public record. And then at that point in time, if it's requested, we produce it, unless it's exempt. And sometimes things are exempt. A lot of confidential stuff is exempt. Social security numbers obviously are exempt. Driver's license information numbers and whatnot are generally exempt. But just know when you're doing an email that you're perpetuating or communicating knowledge relating to official agency business, just know that it could be viewed by anyone. And my first job in local government law was with Polk County, and I remember my mentor in that office telling me, don't ever put anything in an email that you don't want your mom to read on the front page of the Lakeland Ledger, because that's what's going to happen. And sure enough, as I'm going through my career, and sometimes you get a little flip or silly in emails, and the next thing you know, someone's requesting your email from that project. And oh my goodness, why did I get goofy? But fortunately, thankfully, my mother was never embarrassed by me, but it can happen. I just want to warn you, it can so easily happen. So just to be aware that anytime you're communicating your official agency business, someone may want to look at it and read it. So it's all documents, regardless of their physical form or characteristic. And this law the Constitution was adopted in 1968. That's about 50 years ago almost. They didn't see the stuff we see now. And as you've seen in Orange County, for example, the recent TextGate, where text messages were deemed to be, and in fact they are a public record. I mean, I am writing about official agency business, even though it's this transitory type thing that you send and it's gone. But anything's a public record, and even with new technology, in the case of cities and counties who maintain Facebook pages, they have to save all that in case someone wants to see it. And it becomes quite costly sometimes to maintain those records, but you have to, anything that's made or received in connection with official agency business would have to be retained as a public record. As I mentioned, there are a lot of exemptions. Sometimes you'll get a public records request, and there are things in that request that are exempt, and you'll mark through them, but you have to tell the person why. So you have to go to the statute, identify the exemption, and say, this is stricken because 119 point whatever, social security number, or something like that. And that way the receiving party knows why you've redacted, what they call redacted, that document. There's no exemption for unfinished drafts. If you're working on something yourself and you just keep it, you look at it, you don't like it, you throw it away, that is not a public record. But as soon as you share it with someone else and say, here, Mike, give this ordinance a look, now it was a draft, and it still is a draft, in fact, but it's not, it is a public record. So as I mentioned already, there's an exception for personal correspondence. So if you're just doing purely personal business with one another, that's not a public record. It's important to retain these records because they have to be retained in accordance with the schedule. Frequently when we have these advisory boards that are impaneled for a specific purpose that may become contentious, for example, the Orange County Charter Review Commission had a lot of things going on. And when I talked to them about this several years ago, I just told them, I said, I suggest you just create a Gmail account for this purpose, and only this purpose, and it's like danacrc@gmail.com, and then all my emails, you just use that for your email correspondence. But really, we have, in this day and age, we have an excellent backup system with regard to our emails. So if you copy, our city clerk is the records keeper for the city of Ocoee. So the clerk, if you can copy her on your emails about board business, then they'll be retained as a public record as well. The problem is, and I'm sure you've read the articles, that if you use your regular old Gmail account for P&Z business, and then someone makes a request, then you have to go through and dissect out those emails that are for P&Z. And what if you accidentally send one, about Aunt Mary who's in the hospital in Atlanta or something? It's out there now, and you can't take it back. So for that reason, I've always recommended just establishing a separate email account for this business. And certainly with a lawyer or someone who does, or an accountant, someone that does something that's highly privileged and confidential in nature just on a day-to-day basis, definitely do not use that work email address for board business just to avoid the inadvertent slip. So that's always a good idea, is to create a new Gmail account. At the very least, copy the city clerk with all board-related business. Again, the penalties are pretty severe. As you know, with TextGate, I think several of them were fined for the violation. But this is a very serious one if it's a knowing violation. In other words, I knew that I didn't want that email out there in the public record and I deleted it. And it can be, one can be charged with a first-degree misdemeanor. So it's a very serious, serious law that's taken very seriously. And that's why we wanted to be sure everyone was aware of it, because these things, this public records and public meeting, it's not intuitive in the private sector. For us government people, it's intuitive because we're dealing with it every day. But when you're in the private sector, it's just, you send an email and you want a courtesy copy your chair of the board or something, because that's how you do business in the private sector. But in the public sector, that's a big no-no, and you don't want to ever engage in the correspondence outside of the sunshine. So for that reason, with so many new board members, it seemed like a great time to have a little refresher course on this for all of us. So I wanted to give you the information for the Florida Attorney General's office. That is the website where you can get the Sunshine Law Manual, which is an excellent resource, goes through everything, talks a lot about specifics, and it's kind of interesting. They update it every year. And then I also wanted to be sure that you all had our number, the city attorney, Scott Cookson, and then my number as well. And we're always available. One of us is always going to be available if you have a question regarding sunshine law or public records law. And I'll pause for a moment in case you have any questions right now.
Well, what comes to mind for me most recently is that for years, and I have a piece of property that's in the city, it could very well come up before this board as part of some process. And for years, I could still discuss this, even though I would be abstaining from voting, and I would disclose that fact. But that seems to have changed.
Yeah, we're going to get to
Oh.
voting in a minute.
Oh, okay. I'm
Yeah,
sorry.
and that's a good question. We'll be right there in a second, actually, because that's part 2 of our presentation, which is the State Code of Ethics.
Can I interject another question before we
Sure.
go there that's kind of related to this? So this covers communication within this board. What about communication between members of different boards?
That's fine.
No
Yeah.
issues?
No,
Okay.
none at all. If you, as a member of the P&Z, want to go speak to your city commissioner, that's fine. County commission, fine. It's just common board members can't communicate about foreseeable items.
In the same vein, what about, I know I saw something about between a board member and a non-board member,
A
such as a
conduit.
staff. Does that include
Yes,
staff?
that's true. And that, I missed that bullet on that particular slide. I should have mentioned that. That is true. It doesn't really happen very often because staff knows that they can't carry messages to board members. But the idea is that it has happened in the past, not here, but, in history in Florida, where someone would. A commissioner's talking to a staff member, and they tell them something, and then the staff member would take it to another commissioner and say, well, I was talking to Commissioner Smith, and he said this is just a terrible idea, and there's no way he's ever going to vote for it. Well, see, now that person's been a conduit to the message. So, this commissioner should have just been sitting there talking to Commissioner Smith because staff person told him everything. It recently came up in our county, the state legislator from Seminole County who was charged as an individual for violating the Sunshine Law. I forget his name now. He was up for Speaker of the House, and then this all happened. Chris Dorworth. So, he was charged as an individual for being a conduit between two expressway authority members, and they said, no, that's not true for people, like just individuals in the community, but it would be true for a staff person, for Mike, me. We couldn't tell you what another person was thinking or planning to do. That would be just like you talking to each other.
But I can tell Joe Bag of Donuts to go tell somebody something, right? I can tell a member of the public to go tell somebody something, right?
On your board,
Yeah.
like a P&Z member?
Yeah, can't, right?
No,
Okay.
you wouldn't do that. You, as I mentioned, Mr. Dorworth wasn't, they decided not to proceed with the prosecution because he was a citizen, and they found that citizens couldn't be, conduits for purposes of Sunshine Law, but it's inadvisable to send
so that's-
messages to other board members.
So that's a gray area right there, but it's best not to go there.
I would never advise anyone to send a message to another board member through any way, because they look at anything now. They look at Facebook, they look at telephone, they look at computer, they look at email, they look at anything that could get your voice to the person next to you without doing it in the sunshine on this board. Facebook's another real big thing that's caused a lot of problems because someone will post, Commissioner Smith will post, there's no way I'm going to vote for that in that neighborhood. And now everybody on his board knows it. Some of the counter arguments are, well, he could have done that in the paper. And, they do it all the time. They tell the paper how they're going to vote. But I would never, it's never advisable to use any mechanism as a conduit. You just talk about it when you get here. You just say, tell them what you had to say, and face-to-face on the board with the minutes and the clerk and the open door and everything.
Yes, my questions to you, let's say, for example, do I go to like in HOA meetings in my neighborhood? If I've been approached by one of my neighbors regarding a project that's coming across,
Yes,
if something's been discussed openly to the public,
yes.
am I okay to discuss that information as long as it's been open to the public?
Yeah, I think what I might be hearing you say is something that's another issue of ethics, where of something that's not known by everyone. And that we're not allowed to talk about when we're officials. But if you're in your neighborhood, you're in your HOA meeting, your neighbors are concerned about a development or an application that's been filed out on the frontage road, and they want to talk to you about it, you're a P&Z member, yes, absolutely.
Okay.
You know, you hear their concerns, and that's your job. That's why we have people from all over the city, so that you can hear from the citizens and be able to be their voice on this commission. So absolutely, yes, but if it's doubtful that most everything you all see, by the time you see it, it's public record. I mean, we have the agenda, and the documents have been going back and forth, and anybody who wanted to know about that project will know. But with regard to someone like, probably more Mike than me even, if there's some huge economic thing coming in or something that nobody else knows and there really aren't any records generated, then no, we could never talk about that without having, you know, it been made public, because that would be disclosing information we know only because we work for the government.
A previous city attorney, Paul Rosenthal, when he gave us this talk years ago, he said that if you're in that gray area and you think about this and there's any possible perception of what you're doing could be construed as wrong, it's best not to do it.
Yeah, because you don't want the complaint, you don't want to have to answer the
So you have
complaint.
otherwise you have to deal with it, so.
Yeah, absolutely.
Perception is 9/10.
Thank you. The public must be heard. Members of the public must be heard regardless of the location of their residence. Is that correct?
Yeah, there's no distinguishing feature in the law. You can make up, as a board, you can make up reasonable rules that manage.
Whether they
comment.
own, rent, or own a
Right.
rent property or not within Ocoee, it doesn't, so anybody can, regardless of citizenship, regardless of being an adult or a minor.
It doesn't really distinguish whether or not the person is an adult or a minor. Occasionally you see children speak on items at commission meetings, yeah.
And is there a statutory or regulatory limit on the amount of time a member of the public may speak?
Yes, and that's a good question. When they wrote this law a few years ago, they wrote into the law that you as a government can establish reasonable regulations to control the comment. You can set up time limits, you can open the comment at a specific time on the agenda. There are things you can do to control it so that you don't just spend your entire, primarily this is county commissions and city commissions, you know, that have tons of public comment and public input. But yes, they're allowed to have reasonable rules that allow them to control the comments so that it's manageable for them to continue to do their jobs.
Without getting too detailed, does that apply, such a regulation apply to the entirety of the business conducted at that meeting, or item by item on the agenda?
Yeah, usually they take the comment item by item.
Thank you.
Yeah, you can, but you know, if you establish a spot at the beginning of the agenda for the comment, and generally what they do, and the person who's managing the meeting will just say, if you're not here to speak on something that is on the agenda, let's hear from you now. And then people will get up and they'll talk about, you know, animal control in their neighborhood or whatever, and then they leave, and then when the item, the rest of the public's still there, and when their item comes up, then they get their 3 minutes or 2 minutes, or however the board has structured their rules for that. But yeah, if I'm there for 6 items, I'll be heard 6 times for 3 minutes, and you know, and that's fine, but you won't be heard again and again for your same item.
Thank you.
Yes. So with that, we'll move into what the chair was talking more about, which is the state code of ethics, which is 3 parts really we're going to talk about tonight. The standards of conduct, which we've kind of touched on, the voting conflict, which goes to the question of Chair McKee, and then financial disclosure, which I know you all are familiar with because you would have filed your Form 1. But I just wanted to mention, kind of mention one thing that, with regard to Form 1, and that's the Form 1 final. So we'll touch on that at the very end. So the standards of conduct for officers and employees, that's you and me and Mike and everyone in this room, is obviously you can't solicit or accept a gift with the expectation of influence. You cannot do business with your own agency. There are some, I'll talk about a couple of little exemptions with regard to that one in a minute. No unauthorized compensation for the officer, and this extends to the officer's spouse or minor child. You cannot corruptly misuse the public position, and that's the standard, corruptly misuse. So if I just kind of take advantage of my position a little bit, that doesn't rise to the level of corruptly. You have to prove that that state of mind was corrupt. You know, you meant to misuse your public position. You can hold no conflicting employment or contractual relationship, and that means you can't have something that's happening in your life that continues to impede upon your duties as an officer or an employee. You can't hold a job that would constantly bring you in conflict or things of that nature, and that too may be waived in certain circumstances. And finally, the one we already talked about, you can't disclose information that you know by virtue of your position as an officer or an employee to the general public. As I mentioned, not doing business with one's agency and or not holding a conflicting employment or contractual relationship, that can be waived by the city commission in certain circumstances. And those circumstances could be because there's only one provider in the area that provides that service. So I sit on the Planning and Zoning Board, and I also run a laundry, but that laundry is the only one in town that does a particular service that's necessary for the town. So that's a sole provider, and that's not considered then a conflict because you're the only one. Also, business would be, if business is transacted under a rotation system, in other words, there are 3 laundromats in the city, and I'm one of 3, and they just rotate it constantly. So there's no preference shown to me because I'm on the P&Z board. Goods are procured by a sealed bid, or there's an emergency purchase necessary. There are examples. Those are examples of when the commission may waive it, but it's not, I don't think I've ever seen a situation where one of those has been waived in my experience. The voting conflict is what Chair McKee was talking about, and this is a pretty straightforward rule with regard to disclosure and filing forms. So if something comes up, a piece of property you own comes up, it happens to be the property that's the subject of the Sunbelt rental. And so you're sitting there and you must state you know that whatever happens with this property is going to give me as a person or my family a special gain or loss. In other words, it's not a new road that's going in down the street from my subdivision and 500 houses are going to be impacted. This is this is something that's going to affect me positively, or my boss positively, or my child, or some company I work for. If there's some connection that gives you, as a board member, something special, a gain or a loss, then you are going to have a voting conflict. And this is the only time you can't vote. I mean, you as a board member, you vote. But if you have a voting conflict, then you have to state it. I have a voting conflict on this matter. I own the property that is the subject of the Sunbelt rental. Okay, so now I have stated my conflict. There's a form that the clerk will collect from you. It's called a voting conflict form 8B, and they will collect this, and you are not to vote on the matter.
So can I interject a question about that? How direct does the gain or loss have to be? So I'll give you an example of context I'm talking about, and it's actually come up here for me. I was an officer in our HOA, and we had a matter that came before the board relevant to our property. It just had to do with changing the development agreement. And so I recused myself, but it wasn't clear to me that I had any direct gain or loss from that. So.
And I have, as we were talking about with the gray area, I've seen people do that because the road's going to be widened behind my house or my subdivision. I don't really know if I'm going to have a special private gain or loss, but I am not going to vote, and I'll go ahead and declare the conflict and not vote. But actually what's happened in recent years is the legislature has defined what special private gain or loss means, because there was so much question on this over the years. Well, what does that mean? Does it mean, So they actually defined it a couple of years ago when they kind of revamped the whole ethics laws to tell you what it means. And there's a test that we can go through if there's a question about a conflict and you're wondering, is this really going to inure to my special private gain or loss, then we'll look at the statute together and we'll go through that list. And it's a test, really. It gives several criteria that you would apply to determine if, in fact, it's going to inure to your special private gain or loss. But with a development agreement for an HOA with a bunch of members, and there's nothing really coming back to you as an individual, it's coming back to your community, yeah, you would just look at the criteria and see how it, you know, they give a specific criteria now in the law to help guide us when we have these questions.
Okay.
So we'd contact you and kind of go through this
Yeah,
test,
yeah.
explain situation, okay?
Yeah, and I'm going to give you a link at the end for this manual, which is the Florida Commission on Ethics, Code of Ethics, and they talk a lot, they take a whole chapter of law, and, I mean, a whole section of law, and they condense it down to a little booklet, but it's pretty handy to glance through and look at, because it gives you, it just kind of talks to you in plain English about what's going on, and talks about voting conflict. So, God bless you. So, so you would not vote, obviously. Prior to your vote, you would state or declare the conflict. Now, the chair raised a question about participation. And through the years, in this book, in fact, it says that appointed board members may participate in an action. You declare your conflict. I'm not going to vote on this. I own that property. You can participate in that action. I always advise people not to participate. I've seen it in a lot of cases where someone has participated, not here, but other places, about participating, and then you're watching them and you're going, why is he doing that? I mean, don't do that. And it's just not a good idea. But you definitely can participate, and I think what they're trying to do in that instance is just kind of weave that needle to allow you to continue to be a citizen. You're an appointed board member after all. You're not elected. And so they want you to continue to be a citizen, but you can't vote. So I always suggest that the participation not occur either, but it does say in the book about participation, appointed board members can't participate. But do recall that you must state that conflict first, you must file the form, and you must not vote.
So it's not inhibited by the document, but they're going to go back to the perception of the situation.
Or other factors that may be
Yeah.
involved, yeah. You would, yeah, definitely, they have always, and I've talked to them about this over the years, because I've been talking to people about this for over 20 years now, about, advisory board and voting conflict and things of that nature. And you're free as well to call the Commission on Ethics if you have a question. They're very, very welcoming. I'll look at the research and then I'll call them and talk through a fact pattern. But I have this old, and I meant to bring it, it's before they changed the law, so it's a little bit outdated, but it's this old little, they used to put this in a little small book that was kind of pocket size, and it's all tattered, and I've had it for years, and I have notes in there from conversations and opinions and such, and I have that note in the margin, can participate, must disclose, and cannot vote. So it is something that you definitely want to think about, and like I said, you can talk to them about that if you have questions.
I mean, the logic to me would be that if someone has to recuse themselves because of a conflict of interest, then they reduce themselves to the status of any other citizen before the board. They should not have, in my opinion, this dais to articulate their opinion about their own project. And if they want to say something, they ought to go around and say it like a citizen would.
Right.
That's my own opinion, but that's not the way the law is.
Yeah, I was looking for that language in here where they talk about the appointed. It's just no appointed local officer shall participate in any matter which would inure to the officer's special private gain or loss, or the loss of their principal by whom they're retained. That's your employer, or a relative or a business associate, without first disclosing the nature of his or her interest in the matter. The memorandum of voting conflict must be filed with the meeting's recording officer. And that's what we do, that we'll collect from you this form.
Was
But
it,
that's how they word it in
was
the
it
law.
specific for in terms of relative?
Yeah, yeah, they define relative in the law as well.
Okay.
Yes, they do. As I recall, and I haven't looked at that definition in a while, but as I recall, it's your general, your kind of first tier of relatives, the ones you would think, brother, sister. I think it's aunt, I think it includes aunt and uncle, mom, dad, kids. But it is defined in the law what a relative is. And finally, our financial disclosure. This is the Form 1 that all Planning and Zoning Board members file. Just a quick reminder, it's due by July 1 of each year, so it's due. You probably already filed it with the Supervisor of Elections. September 1, they start to notice if it's not been filed, and now, under the law that changed a few years ago, they are able to fine $25 a day for each day it's late after September the 1st.
Who
So,
finds you?
the Commission on Ethics.
Oh, okay.
Yeah, they didn't have any authority to fine until recently when the law was changed, and now they do. It was just, it's late, they write you a letter, you're late, but now they can actually fine you $25 a day. This form is filed with the Orange County Supervisor of Elections, and going back to our public records discussion, it's a public record. And I wanted to just mention this because it's really important, and I think people kind of lose sight of it. There is a final form that must be filed when you leave your appointed spot, and it must be filed within 60 days. It's called a Form 1F. I don't think I brought one. I have a Form 1, but I don't have a Form 1F. But it looks a lot like your Form 1. It just has the F on it. And it's your final form, and it must be filed within 60 days of leaving any board that you had to file financial disclosure on. And it would also be filed with the Orange County Supervisor of Elections. So that form must be filed if you resign the P&Z. Just to mention the penalties, the violation for the Code of Ethics has a wide range of penalties. They are not always, some will be imposed upon someone and some won't. It can go anywhere from impeachment, removal of office, suspension of office, to a fine. So we just wanted to mention that this is part of the Code of Ethics package. When an administrative law judge or a circuit court affirms a finding of guilt, then there could be penalties associated. They have this thing called public censure and reprimand, where they, publicly denounce your behavior in a public document that's released by the commission and such. So they can do any or all of those if they have a finding of guilt. I wanted to give you this Florida Commission on Ethics website and their number. As I mentioned, they always have a person on call. Every day they have a sort of like the planner of the day. They have someone there that will take your call and can talk you through most things. They have access to their research and opinions, and they're very, very, very knowledgeable on this Code of Ethics. Very helpful, very, very easy to get a hold of and talk to. They're pleasant. I have a great rapport with the folks up there. I've worked with them a lot over the years, and definitely can commend you to them. The website is where you would find this document, the Code of Ethics for Public Officers and Employees. It's updated as well every year. And but I can leave this with the clerk if you decide you want a copy. We can scan it and send it to you as well. And there's our number, Scott's number, and my number, if you ever had any questions with regard to voting conflict, financial disclosure, or any of the Code of Ethics provisions we talked about. We're available to discuss those as well. So that's government in the sunshine in a nutshell. I don't know if y'all have any questions, but if you think of some later, you can always reach out.
That's true. We have the number.
Yes, you do.
We have the number. Any other questions by the board? Of the attorney? Anyone? Okay, thank you.
Okay, my pleasure.
I think it's all very clear to us now.
That's a lot of information.
Moving on to the next item. Thanks again.
Sure.
Planner Rumor.
Yes.
We have miscellaneous project status report in July, if you're ready. July
Okay.
calendar.
Yes. We had two pre-construction meetings today, which is the step before they break ground. The first one was for the Oak Trail Reserve subdivision.
Oh, okay.
That's over by Clark Road on the north side of Clark on Ocoee, adjacent
End of Clark Road.
the east side of Arden Park. And with that development will be the southern extension of Clark Road up a ways. There will be a gap in the road.
I thought that one was the one that they backed out of.
They backed out, found another builder. D.R. Horton will be
Okay.
building the
Oh,
product.
Horton's building, okay.
Okay, but they didn't have to go through any new approvals.
It was just, they kept the same.
Kept the same plan?
Yep, same program, so it worked out. Then we had the second one, it's in the downtown area, it's the Foundations of Light. Their, part of their PUD is, it's the mosque accessory parcels. What they're gonna be building is a parking lot. Right now, they have a gravel parking lot. They'll be building the parking lot. That was phase 2. That will enable them to do phase 3, which is add on some buildings on their property. We are seeing, we had a grand opening of the Orlando Gun Club, which is on Highway 50 next to
Yeah.
Pause and Play. The 2 apartment complexes, the Arbors Apartments up on the north side, is nearing finaling their last 2 buildings. The Oasis is about halfway. Interest of note is the Scorman Apartments on McGuire on the south side, recently sold for $50 million.
Wow.
Yes. The commercial out front is still owned by the Scormans, and they do plan on building a 18,000 square
Because
foot.
I saw where they had a big banner out soliciting, people to rent, so I took that as they weren't full.
Oh, yeah, no. The Orlando Business Journal said they were 90-something% occupied,
Okay.
so. Yes. We continue to have a lot of development. We are seeing an uptick in medical office, which is really nice. On the, adjacent to the hospital, we have a development called Citrus Oaks, which was a little development with condo pads. That's being built out. If people are looking along Highway 50 across from the hospital, if they can squeeze in a building where they call us and want to do pre-apps, and so those are good office uses that we like to see. We will be adopting the 429 overlay final on July 18th. With regards to the downtown, if you get the West Orange Times or picked up the free one, you see we did a wrap with an update,
Yeah.
a wrap on the front of the newspaper with an
Yeah.
update on our downtown plans. Blueford Avenue will be beginning to be under construction soon, so if you travel that way to P&Z, it'll start to be a
Maze.
yes, a maze. So, a lot of things happening. You're gonna see a lot of stuff with the downtown master plan coming to fruition all at once. We've got architects and engineers selected, got their contracts signed, doing kickoff meetings. So, a lot of fun going on.
So you've been pretty busy, huh?
Yes.
When are they gonna start, on that Four Locos? I passed by that house today, it's looking even worse.
Yes, so they will, what they're trying to do is get a credit for the existing structure with St. John's, so when they do their new building, they can receive credit. So that's why it's still there. The sewer, which will be running through downtown, is coming from 80 Mims, the sewer plant, down Worst Road, down Lakewood. They actually started up in the curve on Lakewood and went north. Once that finished, they'll come back to the curve and run the sewer down this way. We need the sewer at the intersection of Blueford and Silver Star, and then run a line to their property in order for them to connect the sewer. So they've got some time there, but it's turnaround. Once they get the okay from St. John's, and they can receive some sort of credit. They've got the engineer designing the site plan. We had a meeting last week to discuss the lift station. The parcel's kind of a little island. It's on the north side of Silver Star. There's a vacant parcel next to it, some single family, then the railroad tracks. So we want to do a lift station that can accommodate all those properties on sewer. The sewer line needs to be there. We need to model it. So it's kind of slow, then it'll all pick up. Their idea is their architects running and their engineers running. It's just a matter of those little items.
I missed the briefing last time because I missed the meeting on the city center. Is that actually going to happen?
Yes, I mean, they are over 50% done with the infrastructure on that property.
Wow.
We met with the architects, the structural engineers, a litany of professionals, and the plans are beyond 40%. They just purchased the property on the east side of Bluford, where the Main Street Road is cutting through. They purchased the properties on both sides. The property they own where the city center is going on, they own a piece catty corner, and they actually own the piece across in the partnership. But we will be getting a office building, which will be their headquarters, and some other offices will be submitted as well. So,
Okay. How about the storage facility we just approved down there by across from the U-Haul storage
yes,
facility?
that'll be, they just called me this week and said they'll be submitting.
It's kind of a
Fine.
trashy-looking, sort of semi-used car place right next to that. Is that going
Yes.
to,
I know.
is that
The
going to
gentleman that owned it was here at the meetings.
be? Oh, was it?
Yes, yes.
Okay.
Okay. Speaking of the sewage line, waste treatment line, from Silver Star, does it come south on Bluford now?
This goes all the way down to Delaware, cuts across,
Oh,
it
okay.
goes all the way down to the fire station,
Right,
cuts across the fire station, goes down McGuire to 50.
so it is connected
It
from
is
the,
connected.
okay.
So right now, the new lines stop at Delaware, and we'll be stopping at the curve on Lakewood by the railroad, after you cross the railroad tracks, and then this section in between. They'll do that work,
So
and when
then
they bring
we-
the street back, they'll bring the street back with the new 10-foot sidewalk, street trees, benches,
We'll be
share lanes.
ready for the new owners to take over the properties
Which new owners?
on Oak Street or.
Oh, okay.
Yeah. McKee Street.
We
For the
selected,
connection, to be making
staff has
connections.
selected, it's going to the commission on the 18th for their, taking our recommendation, selection of an engineering firm for the Oakland, McKee, Taylor design and engineering and construction.
So all those properties will be concurrent then as far as the water and sewage?
Well, what they will be designing is, yes, the utilities and the actual horizontal street structure. Yes, but we got to get the sewer downtown first.
Right, okay, I guess that's the part I was wondering.
Yes.
Anything going on with the
Okay.
Chevron property?
Nothing. Nothing. We met with a land broker that Chevron selected to to represent them, and that's been 2 years ago. Haven't heard
Yeah, it was a while.
anything about it.
Any updates on West and Ocoee Popcar? Because the grass is just, I drove by today, grass is almost taller than me.
Yeah. The Ocoee, Popka, and West, it's all Orange County right away. We do have application in for Taco Bell, and we just received application for a new Wendy's up there on the,
Next to Dunkin' Donuts?
down West Road in front of the two vacant parcels, sort of at the end of the public shopping center.
But the one I was talking about, the one right next to
Yeah,
Dunkin'
that,
Donuts.
we haven't had any interest on the parcels adjacent to the
Nothing.
Dunkin' Donuts. The single-family subdivision behind it, the 44 lots is going gangbusters. It's close to being built out,
Yeah, it
sold
is.
out. So,
Any
Coffee shop.
plans on any improvements on Lakewood, north of Ruiz?
no, that's Orange County.
That's Orange County.
Yes, yes. But with the charter school going in over there, people are looking at it, looking at single family. We did put the very north end of Lakewood at Claricona, Ocoee in one of the character areas
Yes.
in the 429 overlay. But I think Lakewood's going to become, there's really not much land. There's a parcel on the corner of Clark Road and Claricona, Ocoee Road that's still in unincorporated Orange County, next to Arden Park, a big piece. There's a piece there at where the pine trees are by you at Orlando and Clark. But other than that, really, Lakewood has a lot of the vacant land on that west side of Lakewood. it's gonna
Yeah.
become the place where we
Think
get a lot of
it'll be
interest. Especially if Eagle Creek, because all those properties back up to Eagle Creek, and that area can change.
For the new members of the board, the Eagle Creek and the Chevron are the same.
Or the same, Eagle, Chevron owns it, they have a subdivision approved called Eagle Creek. That's a new traditional townhome, single-family, large lots, little lots.
Did the commission, city commission change our start time?
No, they want one of the P and Z members to come and ask.
Yeah, and one of us forgot.
Well, I gotta be there next week for the districting commission. I can do that if you want me to.
Yeah, if you remember, I didn't remember last time, so that's why.
Okay.
Yes.
All right, well, I
It's on my-
guess,
it's on my
do we have to put it on the
calendar, so-
agenda, or we just get up and talk?
You can just get up and talk.
Okay. We wanna move it to, what do we say, 6:30?
I guess it was
That was,
6:30.
yes,
Yeah,
the
6:30.
commission 6:15, you guys said 6:30 is what
6:30.
you voted on.
Yeah.
Yes.
My last question, what about the land next to big lots next to Ocoee Plaza, Silver Star? Next to Ocoee Plaza, there's a big lot. What across
that's
from the
big
church?
lot.
What across from the church, the Spanish?
Okay, yes.
Okay.
The company that owns that is the company that's doing the Four Locos restaurant, VMG. They own that large parcel. That parcel's development is contingent upon in order to develop under a real urban footprint, really needs the master stormwater pond that the city's doing part of the downtown bonding, or else a third of that property would be retention. So that one we're working with them on ideas for some townhomes and mixed office along Silver Star, but it really has to wait until not only the sewer's in, but the master stormwater pond is in, so we know how much volume we can hold. They have 3 properties in Ocoee. They bought the piece where the Four Locos on Silver Star, they bought that 5 acres, and then they bought the 2 pieces that go from Oakland to McKee on the east side of the railroad tracks. Phase 1 for them is the Four Locos restaurant. Phase 2, we're working on the piece on McKee and Oakland, and then phase 3 will be the 5 acres.
Mattress one or whatever over there.
Yes, I
Nothing
gotta
more
call
now.
Dr. Koskin. We broke the ground, they received their site permit, was based off the contractor that the property owner at the time had under contract. Then this other company came in, had to put the property under contract, and took that groundbreaking and made it theirs. But that contract has fallen through, so.
They're the ones that want to put the storage facility there.
Yes, yeah, they had a lot of plans.
Yeah. Okay.
Yes. And, they get a hold of the paper and tell them, we want to put in this Spot 8 restaurant and this and that, and without any approvals. And it looks like, Ocoee lost these. But they didn't really have them. That's just, they're brokers. They just, if someone
Yeah.
answers the phone, well, that's a hot one, that's a live one, so.
Fake news, okay.
They,
Anything else? Thank you. I think that's it. With that, I'll take a motion to adjourn.
So moved.
All those is seconded? Okay, all those in favor, just leave. Thank you.